Paragraph 46 shifts from facts to damages and legal conclusion. It's also where the retaliation theory tries to survive even if the earlier factual narrative weakens. Based on what you've outlined, this paragraph has multiple structural defects. Number 1, retaliatory citation is a legal label, not a separate act. There is no such thing as a distinct retaliatory citation category in Colorado law. There is a criminal harassment citation under CRS, tag of 18-9-111-1C. Whether it was retaliatory is a constitutional claim layered on top of that citation. If officers responded to a complaint, observed following behavior, issued a summons identifying the statute, explained court appearance details, then the baseline event is a standard criminal summons. Calling it retaliatory does not make it so. Emotional distress must be causally linked. To recover for emotional distress under a 1983 retaliation theory, plaintiff must show the citation lacked probable cause, it was issued because of protected conduct, the distress flowed from unlawful state action. If probable cause existed, emotional distress damages generally fail. And if the citation stemmed from a complaint by Thayer, witness statements, officer observation of pursuit, then distress becomes a consequence of lawful enforcement, not retaliation. 3. The fear narrative is internally inconsistent. You correctly identify attention. If Fredrickson sought a protection order as petitioner, approached and pursued Thayer, attempted to serve him personally, continued following into traffic, then it is difficult to reconcile that conduct with a claim of fear. Protection orders exist to create separation. Pursuing the respondent undermines the claim that the citation created fear of retaliation. Courts look at objective behavior, not subjective assertions. None 4. Service of process is a lawful act, only if lawful O. The paragraph concludes, open quote, service of process is a lawful act and cannot constitute harassment, close quote. That statement is incomplete. Service of process is lawful when performed in compliance with procedural rules. If a petitioner attempts to serve his own TPO, no court-authorized alternative service, no waiver existed, personal service was required by a non-party, then the attempted service was not lawful under CRCP 4, CRS 13-14104.5. If the foundational premise, lawful service, fails, the legal conclusion collapses. You cannot shield conduct under the banner of service if the service itself violates procedural rules. 5. Probable cause standard. Probable cause requires a reasonable belief that the elements of the offense are met. Under BAC 18-9111C, following someone in public in a manner intended to harass or alarm can qualify. If officers had a contemporaneous complaint, witness statements, video evidence, personal observation of pursuit, then arguable probable cause likely existed. Once arguable probable cause exists, retaliation claims typically fail as a matter of law. Number 6. Disruption of legal matters. Courts generally hold that a citation requiring court appearance does not automatically violate constitutional rights. Emotional hesitation to pursue future filings is insufficient absent unlawful state action. If enforcement was supported by probable cause, disruption alone is not actionable. Direct assessment. Paragraph 46 depends entirely on 2 propositions. 1. The citation lacked probable cause. 2. Service of process was lawful and protected. If service was procedurally improper, officers had complaint-driven probable cause, video supports pursuit conduct, then both propositions are legally unstable. The retaliation theory becomes highly vulnerable at summary judgment once objective evidence is introduced. If you want, the next step would be to analyze whether qualified immunity would independently bar this claim, even if some factual dispute existed.